Welcome back to Heart of Employment, the podcast for California workers. Today, it's a big guest. I am here with founder and managing attorney of D.Law, Emil Davtyan. Emil, welcome to the podcast.
Thank you. Thanks for having me here.
My pleasure. Today, we're talking about class action lawsuits. Big topic, often misunderstood. So let's get right into it. Explain to us what is a class action lawsuit and what do people often get wrong about class action lawsuits?
Class actions are group cases where one employee gets to start a case on behalf of himself or herself and on behalf of other employees. So it's a very much of a phenomenal tool for employees to use, typically when they have relatively small claims that they may think it's too small for me to handle it individually, but the legal system has created effectively this system of class actions to combine one person's relatively small claim with other people's relatively small claims into one big case. There are court or legal efficiency reasons why this type of case exists. Is if you think about if a company has 100 employees and each of them have a $1,000 claim, judge or court would much prefer that all these being combined into one case for their time and efficiency and one set of lawyers helping them rather than for them to deal with 100 different lawsuits coming from 100 different plaintiffs and 100 different lawyers. So it also creates a lot of efficiency. So class actions are a tool that group similar claims together and for court's efficiency for them to be handled together as well.
Got it. So I definitely understand. I think it's clear why the courts prefer a class action lawsuit. So let's say I'm a worker and I have a case, maybe it's worth $900. And I think, why am I going to go through all the hassle of a class action? I got to get an attorney. We got to find other workers, all for $900. Why would a worker go through all that?
One, there's very, very little hassle to be involved in a class action. That's actually one of the common misconceptions of employees who are introduced to the concept of class actions.
Yeah.
There's not a lot of involvement from an employee to initiate and go through a class action because vast majority of the work is done by the lawyers. So the hassle of it is not really there. And I'll explain a little bit why they're not very much involved is because they come to us, we talk to them about what claims they've had, and we start a class action case on behalf of them and other employees. And really, in the amount of time that it takes to go through a class action case, they might spend total of a matter of a few days, maybe one combined day, 2 days, 3 days combined in the whole period of time, because again, vast majority of the work is done by the lawyers. So the hassle of it is really a misconception because vast majority of the work is done by the lawyers.
Okay.
In terms of why a person with $900 claim might consider coming forward with the class action is because a typical $900 claim is not being handled by any of the lawyers.
Really?
The amount of work that is involved in a class action lawsuit or any type of a lawsuit will far surpass that $900 claim, including if you go to court and file a lawsuit today, there's a $1,500 filing fee alone.
Is that right?
So individual remedies are not really available. They are available, but the economics just doesn't make sense for a $900 claim to come to a law firm to be handled. But again, the class action system exists for you to combine your $900 claim with hopefully 100 other people's $900 claims, have a relatively small involvement in a case like this, pay nothing to the lawyers up front because lawyers in these cases work on contingency. We get paid a percentage of recovery. When there's no recovery, lawyers don't get paid. You put that together and think it's not actually just $900 if that's what that person's
Right.
claim is worth, because for the person who starts the class action case, we call them class representatives or named plaintiffs, they also end up getting an extra award. We call that class representative bonus or enhancement, which is given by the judges at the end of the case for going through a case like this.
So this is the person that originally calls up D.Law. They say, I'm not getting overtime pay. And then that leads to a big class action. That's the type of person you're referring to right now.
That's the type of person and any other person who ends up being added to the case as a named plaintiff. So whether you were at the start of it or whether at some point you got added as a named plaintiff.
Anyone. Oh, what's the difference then between being a named plaintiff and not a named plaintiff?
The plaintiffs who are not named as named plaintiffs, we call them class members.
Okay.
They're the everybody else of the class action that the case is meant to help. So class members really just get their portion of the settlement. If we negotiated, $100,000 for 100 people, we're going to calculate how much each of the class members are going to get paid. So everybody gets their portion of the settlement, typically based on how long they've worked for the company.
Okay.
And we calculate that by weeks. Based on the total settlement, we figure out a per week amount, let's say $100 a week. And then depending on how many weeks any given class member has worked, gets that many weeks times that dollar amount, essentially.
Oh.
That's what class members get. Now, class representatives are a little different because they put their name on the case, which is a big deal.
Mm-hmm.
Now, many people want to put their name on the case. They went out of their way to represent not only their interests, but also the interests of other class members. And they did some work. Typical class member just doesn't do anything. They get a notice in the mail saying there's this case, you're going to get paid X amount of money. Most people just accept the money without doing anything. But the person who put an effort, put their name on it, put in some time in helping to pursue those claims, those are the ones that court system, the judge recognizes that this person did something significantly more than what a typical class member does. So they get a class representative bonus at the end. As to how much that bonus is, from our experience, there's no set number one. It ranges typically between $5,000 to $10,000 per named plaintiff. Again, it's not a set number. It's something that judges decide. Every judge is different. Every county court is different. They have different feelings about how much these people need to be awarded for their contribution to the case. Sometimes it can be less than $5,000. Sometimes it could be more than $10,000. Some cases really become very, very involved through depositions, through attending mediations, and through other help where it justifies a higher award. In other cases, judges are not convinced that class representatives should get a certain amount of money. So hopefully that gives you a little perspective.
So one more question on that. So if I want to be a class representative in a class action lawsuit and I'm not the initial one that calls up the law firm and says I'm not getting that overtime, can anybody be a class representative, or how do they, who decides?
In vast majority of the cases, it's the person who starts it, and it's that same person essentially is the only one who remains in the case.
Mainly them.
Exactly.
Okay.
There are other situations where we get phone calls and they want to also participate in the case as a named plaintiff. And a lot of times they understand what the benefits of participating would be. But it really comes down to attorneys who are litigating the case, whether they feel it's necessary to have a second named plaintiff, because sometimes having employees, different types of employees from different lines of work within the same business may be helpful to represent interests of more diverse employees. So it really comes down to the recommendation of the attorneys, who are really the ones navigating, sailing the boat of this class action to decide, does it make sense to add an additional person, and if so, why?
So when you were saying, why does a class action make sense? First, it's because if you have a case that's small, $900, $1,000, most lawyers aren't going to take that case, so it allows you to still take a case into the court system and perhaps get that money back. But I know, secondly, you've said in the past, there's an element of justice here. This is one of the main ways employees can get justice that just goes beyond monetary, but it says, hey, you did something wrong. And you've found in your experience that that's just another main driver of why people want to get involved in class actions.
One of the biggest motivations of employees who want to do this type of a case is it just shows time and again that they've been wronged one way or another.
Right.
Say they've been unlawfully terminated or unfairly terminated. They feel very strongly about it, but when we explain to them that no legal violation necessarily happened as part of their termination, and then they hear that there's this other type of a case that may not necessarily yield them a high settlement proceeds, but it allows them to teach the company a lesson, to go after maybe relatively small claims, they're usually up for the task and are happily involved because they do feel they're wrong. One of the aspects of the outcome, or one of the outcomes of these class action cases, we as lawyers try to do, aside from getting as much monetary benefits to the class members, to also ask or try to ask companies to agree to stop doing the things that they were doing, so that they don't continue to do it. Now, it doesn't mean they'll necessarily follow those because, business must go on, and sometimes it's just hard to comply fully with all the laws that are out there.
A thought that I just had, if class action is going on, and I think perhaps most people watching have either gotten in the mail or something that says, would you like to be part of this class action lawsuit that you have for something you worked for 5 years ago? One, is there any downside to being a class not a main rep? What's the term? Not class representative or class member?
Class member.
Class member. Is there a downside to being a class member? And if I still work for the company, is there a way that if I say I want to be part of this class action lawsuit, that they're going to find out that I'm part of it and that they might retaliate against me?
They're not supposed to retaliate for being involved in a class action, whether as a named plaintiff, if you happen to be still employed, or as a class member.
So it is illegal to retaliate against an employee who wants to be part of a class action lawsuit?
That's correct.
Okay.
But companies have sneaky ways of going around that, figuring out ways that don't look so obvious. Maybe issues that were not issues before become issues after
this is
their
something
involvement.
We've talked about before, yeah.
So very sneaky ways that companies may end up retaliating against people that would be very hard to prove.
Yeah.
Because at the end of the day, it's an at-will employment. They have very broad authority to fire employees. You give them a reason to do it. If they really want to take that bait, they're going to, use that opportunity to do it, but they're going to make it look like a little different than it was supposed to be.
So when it comes to class action, if you want to become part of it and you still work for the company, the risk is not necessarily zero that there will be some kind of retaliation. It's safer to not be with the company more. There's nothing preventing you from being part of a class action if you still work for the company, but there's just it's a factor to consider.
It is definitely a factor from employees' perspective. From lawyers' perspective, absolutely no difference.
Right.
Whether you're still employed or not, you can still have the same type of claims. You don't have to be fired. You don't have to quit your job to talk to lawyers and proceed with a class action case. But you're still employed. If it's
could get awkward.
It will get awkward. People will find out about it. Depends on the size of the company as well.
Yeah.
relatively small company, they're probably going to quickly find out who's suing for what, right?
Let's touch on that real quick. Company size, does it matter when it comes to class action lawsuits?
Typically, yes.
Okay.
A company that has only 10 employees, 20 employees, 30 employees is probably too small. Typically, the really bottom size of companies, maybe 40 to 50 at the very
40,
least.
50, okay.
But it also comes down to not only employee size, but also their financial ability to pay for settlements. You could have a 50, 60, 100 employee workforce, and you can have grave violations, but you might not have money to afford to doing these things. And nobody wants to see a company go bankrupt and then everybody loses. The case gets tanked. Nobody gets paid. You have to go through bankruptcy. Employees lose their jobs. We're not in that business of running companies into bankruptcies.
That's a great point to make. And I think a lot of people are probably listening and thinking, what type of industries are class actions kind of most prevalent? Like how do if I'm working in telecommunications or fast food, I know we're not going to mention any specific companies, but just for employees to kind of keep an ear to the ground, what industries keep popping up when it comes to class actions?
The industries that typically employ hourly workers.
Okay.
Because class actions, 99.9% of class actions affect hourly workers. That's where most of the wage and hour violations happen. Salaried employees don't really get affected by this as much. So the industries, the restaurant industries, warehousing, delivery drivers, food processing plants, chicken processing plants, big retail stores.
Yeah.
These are all industries that have been affected one way or another. Our firm has sued so many of them for a number of different violations. Some of the most prevalent claims in those areas would be not getting a proper lunch break or rest breaks because they may get interrupted, or they're too short, or they come too late in the day. Off the clock work is a really common scenario. We had a case one time about people spending meaningful amount of time putting on certain protective clothing before they have to clock in. Would spend at least 5 to 10 minutes, if not more, to get dressed up and then clock in.
I've heard it. We get those type of cases on Facebook and TikTok, our messengers. People are like, I'm not getting paid to put on my PPE. So that has, in the past, led to class action.
100%.
Okay.
It has not just led to some class actions, but class actions that have settled for millions of dollars.
Wow.
And that sort of illustrates the point as well. Somebody might think, okay, it's 5-10 minutes. What's the big deal? But it's 5 to 10 minutes per day. It could even be 10-20 minutes if you have to then clock out at the end of the day and then have to take off those PPEs off the clock. So it might seem trivial on any given day, but you take that into account on a monthly basis, on an annual basis, it adds up. And even for one employee, it could be worth a few $1,000s.
Yeah.
And then collectively, it could all of a sudden become a much bigger case.
If you can believe it, it's already almost time to wrap up. Time moves fast when we're talking class actions. But I think last question that I think is useful for any worker listening, do I need to call up, when I call up a law firm, do I need to say, hi, I'm calling up to start a class action? Or is the lawyer going to kind of help figure that out for me, A? And B, if they're not calling D.Law, if they're calling another attorney, another firm, how do I know this attorney's doing good? What's the good signs that a lawyer is working on my behalf when it comes to a class action? Maybe what's some of the warning signs that maybe you have a bad attorney?
One of the most common ways that we as a firm, and this may be very common for firms, law firms that do handle class action cases, is vast majority of the people don't come and say, I have a class action.
Right.
Vast majority of the people contact law firms because maybe they were fired or mistreated at work. And the firms that do the right intake or right case evaluation process would want to ask about everything. Tell me about the things that you're calling about, but also tell me about, list of 15, 20 other things that you haven't told me about, but from our experience, they're common violations. So we find ourselves as a law firm typically in a position to explain, ask the right questions, identify the right claims, explain it that these are types of claims that you may be owed wages on. This is a type of case that we can help you with. And then we educate them about what a class action is, how they can benefit from it, how long it's going to take, so on and so forth. So that's what a more typical scenario is.
Got it.
But if they call us and they're like, I have a class action,
You'll
because
take that too.
That would just make things a little easier. But even if somebody is calling about overtime, I'm still going to ask about whether they've been wrongfully terminated. So we as a firm, and I think any law firm who is in this business, needs to do their due diligence, ask all the right questions. I've been, in founding this firm, we've been very adamant about doing a full case evaluation. And sometimes it may feel tedious for some people who are going through our firm, where they go through a very detailed intake interview. Sometimes can take an hour, sometimes can be, hour and a half, is because we're trying to get all the right type of information from them to then lay out to them what tools are available. Is it an individual case? Is it a class action case? Is it a wrongful termination case? Maybe you have a workers' comp claim that you were injured at work that maybe we can refer you to another attorney. So we try to be as comprehensive as possible. And I think to your second part of the question, that's, I think, one of the telltale signs whether you're talking to the right law firm. If you call a law firm and spend 5 to 10 minutes and they're ready to hand you a retainer agreement to sign, they're like, we got your case. That's probably a red flag. It's like, did you really find out all the things that might be happening at work?
Right.
That's one of the things we pride ourselves in as a firm, that we do fairly detailed case evaluation to find out about everything and then lay out all their options.
The more the lawyer knows, the more they can help.
Absolutely.
Emil, that's it. Thanks for being our guest on The Heart of Employment. You were great. And that is it for this episode. If you have any questions, you can email us at heart@d.law. And we're on TikTok, Facebook, YouTube. You can write us comments there, and make sure to check out our videos. And that's it. We'll see you next time for The Heart of Employment.